Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Okay, if we
All righty,
can,
here we
I'd
go.
love to get to this case. If this is our highlight case of the week, I would like to sit here and scratch my beard. By the way, a beard in which I would never for 2 seconds say at this moment with this beard, I should be an interior firefighter. But I went through this. So let me go through this slowly, and you should all be looking as well after this. I think it's called the Bay case, BEY, because that's what I'm going to weigh this against. That was the FDNY case, similar to this, where some individuals claimed that the FDNY's implementation of a no facial hair standard and no growth standard, in that case, which they won at trial court, lost at the Federal Court of Appeals. That case, the court held, I'm sorry, that's an OSHA standard, 1910-134. All right, it's an OSHA standard, and the FDNY has every right for the safety of their personnel and their victims to implement that. Now, one thing you will not see in any further discussion is a discussion of the OSHA standard. So let me talk to you about the facts of this case. It is head scratching only because, well, okay, let me tell you how we got here. So we've got 4 people, Muslims and Jews. I'm Jewish. I'm not, I don't want anyone to say, oh, you made a derogatory comment. No, I'm not. I'm speaking factually. So I'm presuming they're Orthodox Jews who are required to have a beard and facial hair and not cut it, etc. So there are 4 members of the District Columbia Fire and Emergency Medical Services. So we're in DC, right? Not Washington State, we're in DC. And they're asking a federal court to reopen, that's important, 2 religious discrimination cases that go back to 01 and 05. And I'm going to explain what they are and how they got there.
I've got some background to fill in there too. So when you get there, let me jump in.
Okay, so we go back, if you want to go back to the history, right? So prior to 01, and I'll give you 2 very short things, and it's probably a good time right after that to jump in. So prior to 01, the department said, listen, everybody needs to be clean shaven. And the rationale, to my head scratchiness, the rationale is uniformity and appearance. And they lose, saying that's not a good enough reason to have to be clean shaven. Then in 9/11 happens, where we have terrorist acts with hazardous environments. And the department again says, okay, we need to have a clean facial, clean face to wear SCBA. And they said a couple of things which I want to visit about SCBA, positive pressure masks, that blow my mind. Look, I'm going to say something and I'm going to get beat up, hopefully not by the person I'm saying it about, but I am missing something, or these are the least knowledgeable attorneys and department members ever about how they talked about SCBA and positive pressure, but I'll get to that in a second. So they lose, on the first.
Let me jump in, Brad.
Yeah,
let me jump in only because I have some inside knowledge on as to how the attorneys argued this case. And these are the first 2 cases back in 2001 and 2005, 2 separate cases. They were combined. And if you remember, after 9/11, the federal government started issuing these filter masks because they realized that we had first responders that were police officers, other types of law enforcement. We couldn't get everybody trained to SCBA. We couldn't possibly equip every unit, but we didn't know what was coming next. So they came out with these negative pressure filter masks.
And negative pressure is very important as a fact here.
Right. They were given to police officers, all sorts of different first responders. Okay. So that was issued. So now we have these 2 suits challenging the beard requirement. And apparently the DC attorneys decided that it would be easier to win this case by conceding the positive pressure issue and saying we need to make sure that they're clean shaven because we also have these negative pressure filter masks.
And they are
And-
nuts for having done.
Absolutely disastrous for the attorneys to have made that decision. But what they listened to the plaintiffs make the argument that positive pressure and beards, positive pressure masks make beards okay, which is baloney. Okay, but that was the argument.
That's what's
okay,
killing me here. I can't understand it.
I gotcha. So, but the attorneys decided they made a strategic decision that we're going to win this on the negative filter mask. Okay. Then they get to the trial, the hearing or whatever. And the testimony is that never in the history of DC has anyone actually worn a filter mask. I had to wear one of these filter masks.
Enter COVID.
And what's more, because they're firefighters, unlike police officers, they're going to have positive pressure masks with them. And the bottom line is, based on that, they lost the case. They waived
COVID.
I'm sorry. No. This was all before. This was all.
Enter
so,
COVID.
Okay, but wait. So now what happened was, in the case, the judge issues a permanent injunction against a certain rule that required, basically clean shaven interface at the mask. So now we have a permanent injunction in place in DC, and now we have COVID.
Right. And the permanent injunction was based on horribly, you and I would never have conceded.
Yeah.
Right.
Flawed strategy in the litigation. Absolutely.
Oh my God. Horrible. Yeah. And to say, well, fine, you can wear SCBA instead of an N95 or whatever. Right. But again, even though I'm guessing probably having N95s were required on the ambulance for some purpose here as filtering masks, right? Which is crazy to me. If it's sitting an inch off of your face, it is not filtering anything. A half inch, in your case, 6 inches off your face, right? Hey, well, Billy Goldfetter would be 7, so you haven't quite got there yet.
I'm Avis. I try harder. We're number 2. We try harder.
So COVID comes and they say, hey, wait a minute, national standard. These are my words, not theirs. This would be my argument, but they say, change of circumstances, February, March now has come of 2020. We need to wear masks. Although interestingly, and we're going back and forth, remember, in 2020. We need masks. Don't wear a mask. You need 2 masks, right? I mean, so it was, they were up against the wall anyway. But in any event, now they said, listen, we have a pandemic. All the rules have changed. I think that's what they're saying. Now you got to wear a negative pressure filtering mask. And so change of circumstances, pandemic. I have to say, DC should win here. How can you say you can't require masks? And I get it, permanent, but change in circumstances on a 500-year event, right? Or a 200-year, whatever we decided COVID now is, right? Nobody predicted a pandemic since the Black Plague or whatever. And the court just didn't think about it, right? And no, the court should have issued a permanent injunction, meaning forever, because there could never be change in circumstances. They did. That's what's being challenged. Now, let's deal with this in 2 parts, because the first part is now, the first part is, where do you evaluate this? Today or in 2000? You have to evaluate this back in 2000. And for damages purposes, at least, you have to go back to 2000. Whether today that rule can continue to be enforced, saying you have to wear a mask, right? And I think it would be. I think if the employer says, look, the preeminent thinking is you need to be able to wear a mask, it has to have a tight fit, and you can't fit with a, Curt Verone beard here, and theirs are much bigger, by the way. They have chin, right? They're not just pushing it off their nose because it would be over their nose, right? Yours wouldn't be a problem, obviously, but the Orthodox Jews and Muslims could have great big bushy beards, and there's no way it's sitting within an inch or 2 of them. Even if they pull it tight, fine, but there's still a gap. There's still a centimeter, whatever type gap. And universally, we accept that under 1910-134, you got to have a seal on an N95. The problem here is they use the old admissions about positive pressure SCBA, and they are ridiculous. for example, one of the things they claim in the complaint is, hey, DC admitted that there's no big deal with a non-tight fit on a positive pressure SCBA because that just blows the air right out. What? Wait a minute. Assume for the moment that fine, there's no danger to the firefighter, which is BS, because I've accidentally been in a fire with it, and it, you know, it has a seal and they take a breath and some hot air comes right in and you feel it, right? So it doesn't blow the hot air out. It may blow cold air out, but the other point is you're losing your air, right? If you don't have a seal, the air keeps flowing. I don't understand why DC made that ridiculously inane comment.
I just told you why. It was a strategic. And again, Brad, this goes back to the problem we have. We have non-attorney firefighters. I'm sorry, non-firefighter attorneys.
Yeah.
Okay. We got non-firefighter attorneys arguing a case involving the fire service in front of a judge who's not a firefighter.
Right.
Okay. And they don't understand what's fact from fiction. If you had a courtroom of firefighters, it'd be one thing. Okay. So you got these two, and they made a strategic decision, and it's crazy. But the bottom line is OSHA has said, and they reaffirmed it in the New York case. It is the Bay case. I double checked it, right? Bay et al. Versus City of New York. Yeah. That you have to have, even with positive pressure, you have to have a clean seal. There cannot be facial hair at the interface, period. So basically DC since 2007 has been in violation of OSHA and NFPA requirements and NIOSH.
And the interesting part about the Bay case is, one of the arguments in the Bay case is that the FDNY switched from saying it's okay for the firefighters not to be clean shaven. And they alleged at the Second Circuit that the FDNY switched its view and said, well, now we require clean shaven if it takes 2 or 3 times a day, no growth. And one of the points the firefighters lost on is that the FDNY was being irrational and didn't have a true standard because it switched. And the court specifically held, the Second Circuit specifically held in Bay, that the FDNY was allowed to change its standard, was not bound by the past, and could come up to, modern times by requiring the clean shave. Now, there was no permanent restraining order prohibiting them from doing that, but I question how any judge could have issued an injunction had the issue of 1910-134 been raised. I don't think it was. And how do you not raise it for that type of mask? And even if you're talking about—
They thought they were going to win. They thought they were going to win on the negative pressure. It was a strategic mistake.
Horrible.
It's like starting out with 1 3/4 when you should have started with the deck gun.
Right.
It's a strategic mistake, but you're already committed to it now.
And to do that, they must have thought, what? The positive pressure SCBA was going to be an universal supplement for wearing a mask? Come on, we're just not doing that.
Again, non-firefighter attorneys arguing a case before a non-firefighter judge.
So we should make specific point to keep following this case. Obviously, you will, but because I got to say, the motion, I would be making a motion to dismiss based on the Second Circuit, Bay case. It is so close. It is so close. And I know it's different mask, but it's and a little bit different scenario with an injunction, but you can't have an injunction against a mandated federal activity. I don't know how you can agree to waive federal law, right? That's designed to protect all of your employees.
Well, I got 2 points. And they're going to piss off people on both sides. So, but the first one is that DC screwed up again. They should have went back and asked to have the injunction removed or quashed, or whatever the term that they use in DC would be. But here it'd be quash the injunction. Okay. Yeah. That's what they should have done back in 2020 when they first decided they needed to re-implement the facial hair. So that's, you don't just ignore an injunction. Okay. So it's possible they could be in contempt. Okay. Now that's issue number 1. Okay. Secondly, I know a lot of my friends in DC have beards and they want to keep their beards and so on. Okay.
The fire
So
department?
on the fire department, yeah. Oh
Wow.
yeah. DC fire. Oh yeah. So now here's the thing. Oh yeah, they're like not liking the discussion that we're having here. So that, which is
Okay.
fine. Okay. But here's the thing. Okay. NIOSH, as sort of the research branch of OSHA, not the separate organization, but really OSHA depends on NIOSH to do the research. Okay. What needs to happen for the folks who want to continue to wear beards is NIOSH needs to go back and revisit this with modern research. And after that research is completed, if indeed it shows that positive pressure can be worn with facial hair at the interface, then OSHA should change the standard. But you can't do it the other way around. It's not smart. It's not safe. Okay. The research comes first, and then we change the standard. But you don't change the standard just because, for whatever reason, you feel that you want to have a beard. Okay. Do the research first, and then make the change. If that's what the research suggests, that's the proper way to do it. Okay. So we'll see how this all plays out.
It's going to be very interesting. Great case. I'm hoping there's a motion to dismiss. Honestly, just so we can get some quicker answers.
If I'm the judge, whether I was right back in 2007 or wrong back in 2007, I am not going to be happy that they ignored my order. That you have an injunction, you come back into me and give me the opportunity to change the order. You don't just ignore the order.
Although I think you have to, I'll give you a couple of reasons why it might not have happened. Remember what happened in 2020, March? Courts shut down, at least New York State, courts were shutting down.
But there was still the ability to get and I would have done it on an emergency. We're talking about an emergency hearing.
Agreed.
And an ex parte hearing.
Right. Had they done that with the panic and the pandemonium that was happening in 2020, I think a judge would have said, sure, we're not going to, allow you to send people out without a mask. It's not their choice. But, this case addresses mandatory vaccines in some interesting ways, right? Because here we're saying the employer has the right to tell you what to do for your safety. Either the employer has that right or doesn't have that right.
Mm-hmm.
I think this case is so far-reaching because it's got to show the change of circumstances are warranted by the pandemic, by an employer's duty to provide a safe working place, by OSHA requirements, by the prior bad calculated tactics they took, whatever it is. This court has got to come out and say, because there's so much precedent on mandatory vaccines and other things, that you must allow the employer to mandate proper fitting masks. And there's no other, says NIOSH and OSHA, there's no other right now. There's no other change. There's no strip you can put in. There's no pull it really tighter. There's no alternative to clean shaven at the present time. They've got to lose, but let's see what happens. I can't.
Let me throw out another argument. It's kind of like what do we call a sharp practice? Which my uncle always said, don't engage in sharp practices in the practice of law. That's sharp practices where you're really kind of doing something that's borderline here. But here's a sharp argument. Okay, the injunction, and I put it in the post here. It says that the defendant, basically department, the DC. The District of Columbia Fire and Emergency Medical Services, or FEMS, basically it is permanently enjoined from enforcing the facial hair provisions of Special Order 20, Series 2005. Okay, so now sharp practice say, well, yeah, we rescinded that one and we came out with Special Order 21.
Right, which they say is it's the same thing, and
I get it. But if you're saying, well, we're gonna, this is the issue here: is did you violate the order? Did you ignore the injunction, they can say, well, no, we didn't. We actually honored that. We didn't enforce that anymore, but we came out with a new, I think, safety operations bulletin number 10.
Yeah, not
So
the
we
same
can,
thing.
it's, you know, so we complied with your order. We just came out with a, you know, same principle, but we came out with it with a different number. So whether or not that's going to, you know, be a sharp practice, whether or not it's going to, you know, give you a colorable argument when you go back before the judge. And I'm not even sure that that judge is still, you know, he may have retired, he or she may have retired. So.
Yeah. And again, the whole argument's got to be COVID pandemonium. And by the way, we now know more than we do, but I'm citing Bay, and based on Bay, I'm sorry you lose.
Bay is pretty compelling. It's a Second Circuit ruling.
Very smart court. Second Circuit's very well respected. You know, they're a smart court, and I think they're going to be heavily influential if this goes, you know, to the appeal. But at the district level, it's got to be very, very, you know, it's binding. I would say, I would argue it's binding precedent because it's dead on point, but for a permanent injunction. So anyway, going to be super exciting, and I think everybody should be watching this.